Good morning. This is the Vanburen and Tyra case, posted under proceedings D15519168. We have Mr. Root present for the plaintiff. Just state your name, please, Mr. Root.
Hi, Your Honor. Michael A. Root for Jason Vanburen, bar number 002461.
All right, and we have Ms. Tyra present. Ms. Tyra, I don't even know whether you need to be here, but I wanted to have you transported over here because I got a call yesterday saying that you were in custody. And I don't even know whether it's because of stuff that happened in this case or stuff outside of this case. But when they contacted me, there was an order to enforce the custody order, there was a pickup order, and a warrant under 125C0055. And so all that process is to an effort to enforce the custody orders that are in place in this case. So I wanted to make sure that we had a hearing. I wanted to make sure you were not in jail on a warrant in this case.
It is in this case.
Well, it is in this case. I want to make a record. I don't know. They didn't tell me anything except that you were in custody. So I wanted to make sure you were here, so you were not in custody on this case unless there was a reason. Okay. So, Mr. Root. The matter has come on for hearing a bunch of times, April 10th, May 22nd, June 26th. We've had issues with the enforcement of the custody order in this case, and in those hearings, some of them Mom was here, some of them she wasn't, but the party's child was not in your client's possession. And so the court issued a pickup order, which was unsuccessful. We issued an order to produce the child, and under 125C0055, the court issued an order for a warrant so that she could be compelled to produce the child. Now that warrant, do you know whether Ms. Tyra is in custody because of the warrant or because of something else? Okay.
Your Honor, what I heard from my client.
How long have you been in jail?
Since the 3rd.
Oh, so just 2 days ago?
Yeah.
Okay. And how did you get put in custody?
Because Metro was called and they said that the district court wanted me for contempt of court.
So did they give you any papers when they arrested you?
Just when I got here.
Is that a paper from this case?
Yeah.
Okay. I don't know. I didn't know whether you got picked up on a traffic
Yeah, no.
or some other thing.
There's nothing. I don't do trouble to go to jail.
Okay. So Randy, let me see what she has and we'll give it back to you. Let me see what it is. That's okay, but maybe there's a reference here. I don't know, so I want to find out. Okay, so where were you when you got arrested?
At my house.
They knocked on the door and you answered the door?
No, we were outside, me and my son.
And the police came up and they said, we're going to take you
Yeah,
into
because
custody.
I have yeah.
Okay. Where is Dustin? Randy, you can give us back to him. Where's the child?
He's
Your
with
Honor,
Jason's mom.
All right,
Your Honor, what happened was, if I could have a minute here, what my client said was she was getting evicted from the premises and she caused trouble. This is what Jason says.
No.
And as a result, the police were called because the police have a standing policy that they don't physically, by force, enter into the premises, unless, of course, it's a criminal case. So this is the situation. So she must have caused a disturbance outside of this case. Police were called. She was arrested. They found out she had a warrant.
Okay, but so it's your understanding that she was arrested because of the warrant that was issued in this case?
Yes.
That's my understanding.
Okay, well that's
not my understanding.
That's fine. So what happened?
What happened, according to my client, that's how I know, is that Dustin was taken to juvenile hall, and then he says, he thinks there was a juvenile hearing where his mother, who's a court-authorized representative to pick him up, showed up and took the child. That's what he thinks.
Okay. Is Dustin physically with your client?
Yes.
Okay. And was Dustin delivered to your client or to his mom on the 3rd?
I don't know.
Okay.
It all depends if there was a...
Let me ask Mom a few questions. Ms. Tyra, were you part of any proceedings at juvenile court or juvenile hall?
No.
Okay. Did they take Dustin, when you were taken to jail?
Yeah, and then they called my daughter. My daughter's in Arizona visiting her husband.
Okay.
She couldn't get him, so they called the grandma, and the grandma came and got him and gave him to Jason.
All right. Well, this let me just say this, okay? The most recent custodial order before the proceedings this summer was the decision from 2017. It was a joint legal custody order. There was a primary physical custody designation with Dad. Mom had visitation. We had a dispute in April because Mom had visitation and then she didn't return the child. The child missed the last month of school, and Dad's attempts to get physical custody of the child were not successful. And the provision of 125C0055 says that the court can issue a warrant for the arrest of a party to secure the appearance of a child, and the court issued that warrant. It was dated in June. Ms. Tyra's in contempt, but we're not handling this like contempt. We have a clear order, we have notice of the order, we have violations of the order, and the warrant for arrest was not issued to punish her. It was only issued to secure the appearance of the child so that the child could be given to the custodial parent. So if the child is with the custodial parent, then there isn't any reason to impose any indirect civil contempt sanctions. And you know, if she's in jail on other charges, then that will play out. If she's in jail on this warrant, then she should be released from custody as soon as they can process it, okay? I'm going to ask the transportation officer, you're not under oath, I'm not asking for anything in particular, but around 3 o'clock yesterday afternoon, my office got a call, which is typical if I issue a warrant and that somebody's in custody. I need to put this on right away, and we said, hey, can we get this on tomorrow? And we coordinated a notice to the council on the other side and to transport over. Is she being held just on the warrant in this case?
The only thing I have on her charges is that it is a contempt of court.
Okay.
That's
So-
the only thing I have. It doesn't have any other.
All right, so if the court issued a written order, and I need to do an expedited written order, vacating the warrant, or, because this is a tool to compel someone to produce a child if they're hiding the child or if they're not delivering the child. And so now that the child is with the custodial parent, she shouldn't be in custody anymore.
Right.
If the court made those findings on the record and issued a written order vacating the warrant, then how would that process work? Would you transport her back and then begin the process of releasing her?
So I take her back from here, back to where she's currently housed at. And once the records department receives from you guys a release order that she's to be released and that the warrant is vacated, and they'll begin to release her.
So if the court issued an order saying that the bench warrant pursuant to NRS 125C is vacated
Correct.
and she may be released, is that sufficient for you guys to be able to act on that?
Yeah, yes,
Okay.
as long as there's, yeah, if there's none, and
What
it
is
doesn't
the-
seem to
what
be
is-
anything else, it's a.
So if, you know, I haven't written an order, I gotta write an order. If we got an order done in the time it takes you to transport her back, and what would be the way that we would get it to records or to you at the detention center?
My understanding is you send it to the records department.
So
of
we
the
could
jail.
call and say, do you have a fax number?
Right, get a fax
Like we
number.
handle like
and
TPOs and
just-
other stuff.
Right, exactly, any type of releases would be done through there.
Okay, so, all right, so, Ms. Tyra, look, this warrant was issued for one purpose and one purpose only, and that was to require you to be here to produce the child. The child, I mean, it worked to the extent that you were picked up on the warrant.
Yeah.
Maybe it was a matter of circumstance because something else was going on, but either way, your client got the child back. There isn't any reason to hold her anymore. Now, if this was an indirect civil contempt matter, or even a criminal contempt matter, I would have to go through a different procedure. I may have to, if I was gonna, you know, like for instance, one of the sanctions for contempt is a sentence of 30 days per count, that kind of thing. If I was considering that kind of stuff, I would consider having a lawyer appointed for you, or you getting a lawyer. That's not what this is about. This is all, every time I see you, I say the same thing. This is about enforcing and following the court order. I never wanted you to be in custody. I don't want you to be in custody, but you were in custody because the child was not with the custodial parent. And so what I'm going to do is on this record, I'm going to make a finding that the warrant is the reason why she's in custody. I'm going to issue a written order that explains as briefly as I can in a couple of pages what's happened. And I'm going to state that the purpose of this type of a warrant, which is to compel compliance with the order and compel delivery of a child to the custodial parent, has been accomplished. And that the bench warrant should be vacated and Ms. Tyra should be released. And that may take a few hours, but, you know,
Judge standard release time is between 12 and 24 hours?
I mean, that's fine. I'm not asking you to do anything different than standard, but I'm sorry I didn't get a chance to hear you yesterday, okay? I didn't get notice until yesterday afternoon that you were in custody.
Can the court direct a question to her, since one of the other purposes of civil contempt is also punishment?
Well, this isn't civil contempt. This is an order pursuant to a statute. That's why the court was able to issue the warrant on her failure to appear.
Yes, sir. But we do reserve the right to ask for regular contempt.
There's going to be, unfortunately, we have unfinished business. We have unfinished business on any relief that you may request in the future. We have unfinished business on her side because her rights have been affected by the circumstances of the last few months. And so the matter's going to be closed with the end of this order. But if you think that I'm thinking that this case is done, it's not, okay? But first things first, the issue that I needed to address immediately, because this warrant is only intended to compel compliance. If your client didn't have the child, then I would be keeping her in custody and using the coercive powers of the warrant.
Can the court make a finding that it wasn't due to her that my client has the child back? She's kidnapped the child since April 22nd.
Again, look, of course I know that.
She's
I'm
nuts.
drafting the order, not you.
Yeah.
I'm going to draft the order that's specifically related to the most recent circumstances because of the interest of time and because I want her out of custody sooner rather than later. It's not going to be a 20-page order. It's going to be about a 3 or 4 or 5-page
I
order.
understand it.
It's going to vacate the warrant and order her release, and it's going to close the matter, and that's all it's going to be. Now, am I precluding any kind of relief by either one of you in the future on appropriate grounds? No. But we had orders in place to make sure that your client, who's the custodial parent, had the child. We've been, 3 months, 4 months now wrangling with that?
4 months.
And so now
13 days.
now we're at a point where he has custody of the child, and the purpose of the warrant has been satisfied.
Yes, sir.
And the fallout from that is a different matter.
So the
okay?
court is just addressing the warrant today.
That's all we don't have anything on calendar except for what the court requested, which is the production of the party. I owed it to her to make sure that I heard this as quickly as possible because of the warrant. It resulted in her being put in custody, and so she needs to be heard immediately and have that resolved. So we're done for the hearing today. I'm sorry about the miscommunication. I know that some of us are here. Pay attention to him, and I hope you get out
the wrong
sooner.
jail,
Sooner
the
rather
wrong
than
place.
better. I know. Thank you, Mr. Root. I appreciate your
Bye.
getting here on short notice.
Yes, sir.